All right. Thank you for joining us in our latest installment of IP at Lunch. Unfortunately, Phil won't be able to join us today, but I'm very excited for this. This is our episode on fair use, and fair use is always a super hot topic. It is an area of law that since I was growing up, which was a few years ago, that has been heavily discussed and heavily debated. People have been fighting over fair use for a really long time, and let's get into um, what exactly is fair use, right? Um, so when we have fair use, what we're really talking about is the idea that, hey, somebody's got a copyright to something, but it's important that we allow, as a society, conversations and discourse to occur that may slightly infringe on that copyright. And fair use is just a carve out in the law that we talk about when we're talking about this type of thing. It's an exception to the rule that allows somebody to do something. Now, it is one thing I really want to really emphasize here. It's a defense. Um, it's not a catch-all. It's not going to be a great shield, but it is a tool. And so that's the entertaining piece of all of this, is that it's very much subject to interpretation. And there's a lot of law um, that kind of talks about um, how this will be applied. Um, so when we have um, these issues of fair use, it's always something that you should definitely be talking to an attorney about. And it should be an attorney licensed in your state, because fair use and copyrights and trademarks and all of these IP pieces, there are both federal and state implications. So emphasis here, talk to an attorney in your state and think through, what exactly is it? Um, what exactly is it, and kind of how does it apply in my particular situation? So with that, now it's time for our favorite time. It's our favorite time of every single one of these, and it's the disclaimer, right? Um, I am an attorney. I am licensed in Illinois and Iowa. However, just watching this doesn't establish an attorney-client relationship. You should definitely talk to an attorney licensed in your state and licensed to practice before any other relevant boards or authorities that may impact your case. Um, so let's talk. Um, let's talk about fair use, and let's get back into the conversation here. So with fair use, we've got a lot of different things that fair use can mean to different people. Um, and um, um, when we have fair use, let's start with the basics. We kind of talked a little bit about, what is fair use. We kind of defined it, okay? Let's talk about some common myths. 10% or 30 seconds. To be completely clear here, um, fair use does not automatically attach if you only use 30 seconds of something, or if you're only going to use 10% of something. Um, in a very real scenario, you can theoretically completely infringe on somebody's right to something in 30 seconds, or by using 10%, but it really depends on the context. So the best cases of fair use are typically in an educational context. This is fair use is it's a flexible exception to U.S. copyright law, and it's generally there are four things that we look at to determine whether or not something is or is not fair use. So the first thing is purpose. How is it being used? The second thing is kind of the nature of the use. So what exactly is going on with this, right? Um, how much is a factor, but it tends to be looked at more through the lens of, well, what's the purpose and the nature? And then is there a market effect of whatever you're doing? So does it somehow damage the creator, or, in the sense of things is really, can this be used as a substitute for or harm the market or licensing potential of the original thing, right? So basically, could the creator get less money as a result of your use? And so that one, in any commercial context, is almost always going to be, well, yeah, you should have licensed the thing, right? Um, so, these other three though are dicey. So how are you using it? What exactly are you doing with it? Is it somehow transforming the content? Is it commercial or nonprofit use? For nature, is this just you're using it as a factual, or are you using it as some sort of creative thing? Is this going to be published? Is it not going to be published? Where is it going? Right? The amount and sustainability, questions are really, are you sharing the heart, the core of the work, or are you just sharing like a little itty bitty tidbit of it? There's no bright line rule here. Um, it's very squishy. Nonprofit or educational use doesn't automatically get you out of those copyright rules. Um, but it helps. And so um, when we have um, um, when we have those fair use exceptions, um, and we have somebody who maybe might be using something, we're always going to take a look at, well, how much, right? So let's talk through, some of the things that we see, things common, parody or transformation. There's a lot of law that goes into this, but basically, um, if you transform or you're creating a new expression or meaning for something, maybe that might reduce the weight of those other factors. A great example would be like if you're providing commentary, you're making a comment about the context of whatever it is. So, I mean, all of these folks commenting and providing commentary about the new Taylor Swift album, they're providing commentary on that, and they may provide tiny clips, but that certainly helps their case that they're providing a fair use, usage of the original work. And Taylor Swift is really impressive, actually, for her use of copyright. She, as any Swiftie will tell you, is very good at protecting her copyrights. She's excellent at maintaining those copyrights. So there's a reason that she has become what she is, and largely that's due to intellectual property and zealously guarding it. Um, so things that might target or the original work tend to have pretty strong protections. But things that just provide commentary, are still going to help people um, figure out, what this means, certainly can potentially be protected. Whether or not something um, is getting to the heart of the work. Let's talk about the heart of the work for just a second. Um, when we have this heart of the work question, verbatim excerpts can theoretically defeat a fair use argument. If those things are so core and so central to the underlying work that they basically eliminate the need to read the underlying work. And so if it cuts into the ability of the creator to receive payment for what they're doing, odds are you probably don't have fair use. And that's kind of one of the core concepts here, right? Um, you know, sometimes people will take a look at, searches and snippets. You know, is this something where, maybe I think Google has there's a case involving Google, if memory serves, and they talked about, well, Google provides these little snippets, of the content. Is that fair use to kind of give people a sense of what's in the underlying website? And courts have historically held, yeah, these little snippets a lot of times may be fair use as long as there's no underlying ability to substitute those snippets for the original. Again, so that's the key here, right? You're hearing this, and you can't, if you're able to substitute the underlying snippet for the original or the underlying piece for the original work, then a lot of times I think you're going to find, courts are going to be less sympathetic. Um, so, and there's really some complex stuff that goes on here, especially with these AI companies, and they're using these copyrighted documents for training. I mean, there's certainly there's a big argument going on about, well, what exactly, are they violating fair use by doing that? Well, maybe, and that's big. It's going to be a big fight for a long time, I think, and people um, might need to ultimately license this data for training. And so, if you're building an AI model, certainly something to consider. But if you're not, even then, you have to be kind of cognizant of the fact that your AI might be spitting something out that might be copyrighted. So, certainly think carefully before you go and just copy and paste out of the AI. And I think we've covered that for a host of other reasons. Okay, so let's talk, how much can you use? Well, let's talk, practical matters. Maybe you've got the latest track of, whichever band is popular. It could be, right now it's Taylor Swift. It could be later on, it could be some other band that's very popular, right? And you play that over top of your new short that you've created for, be it YouTube, TikTok, um, Instagram, if you're old like me. And so uh, basically you play this thing, and you're talking about something, right? And maybe you're doing something commercial with it. Well, if you're doing something commercial with it, if you it will depend on your licensing, and it'll depend on where you're getting the music from. If you're from, and what your contracts are. So if you're creating this thing in a yourself, and you've created it, you've pulled down the music, you've chosen your snippet, and um, you've just thrown it up, you may or may not have licensing for that, depending on which platform you're on, or which what the platform's agreements are, depending on what your contracts are. And so it's important that if you are going to use it, you get a license, especially if it's going to be commercial in usage, because that's going to be, again, the sense of, hey, if you're commercializing something based on something else, odds are you need a license for it. Even if it's less than 30 seconds, it can still be infringement. And you may have the pleasure of paying quite the fee for using that unlicensed when you get the demand letter from whoever it is that you should have licensed it from. So again, encouraging you, get a license, make sure you have the license before you use that music. Quoting an article in maybe like a blog or maybe a newsletter, you've got 100 words, right, quoted, and you're using this to kind of comment or criticize, um, how somebody approached something. As long as it's not replacing the um, core, you're probably okay. It's not going to be going to people who are seeking to replace whatever um, that thing is that you're commenting or criticizing, you know, um, but it'll depend on how you're going to use it and how you're going to um, um, think about it and what exactly you're doing. Now, if there's no risk of substitution, odds are, you're probably fine. But if there's a risk that somebody might substitute it, maybe not. And if you're adding analysis, the stronger as you add more analysis, as you do more analysis on that snippet, you get a stronger fair use argument. But these are, again, there's no smoking gun, there's no perfect fair use here. It's, you're looking at it and you're saying, okay, well, maybe we need to take a look and make sure that we're doing everything here, right? And maybe, and if you're using it again for commercial purposes, sometimes, licensing the thing is the right answer. Non-commercial purposes, if you're just doing commentary, maybe you might be okay. Um, Product photos from your competitor's website to just kind of compare and contrast. Well, we've seen a number of times where, you snag that photo. Well, who owns the copyright? Well, they can do a number of things to get that thing taken down. So when we have those instances where you want to leave it up, maybe you might want to license the photo, or probably they're probably not going to license it to you, but maybe get your own photo, right? And if you're going to if you're going to do it, there's certainly, a set of conversations that we should probably, you and your attorney should probably have. So certainly, and the way that you might do it is you might reshare the original post, right, and then comment on it from there, and that sometimes may help reduce some of that risk, and that brings us to embedding versus copying. If you have a choice and you're able to embed something where you're just saying, hey, look at this, this is where the original image is, and we're just embedding this, and that way the original owner retains control. We're almost always going to favor embedding over copying, just because it reduces the risk a little bit, as opposed to copying. But there's always that risk, right? It's always there's always a possibility that even embedded a photo or a video or anything else may still violate a copyright. And so certainly something to keep in mind. Internal training decks, oh gosh. So if these are non-public and for instructional purposes, it does help, but it's not automatic. Again, it's really kind of, if it's just factual and you're just taking a picture and you've got this picture, and you're like, hey, this is what they've got, there's no distribution outside of the team and it's just purely for training purposes. Okay. Odds are, and it's never going to be distributed, odds are you're probably okay. But again, you gotta be fairly sensitive about scope and exactly what you're using this for. So certainly something to keep in mind. And so the questions that we always have to ask is, and this is kind of the screener questions. So the screener questions are, number one, does it create a new or different purpose when you're commenting or criticizing? Number two, is it the minimum amount that you absolutely have to have? And does it go to the heart of the work, right? Because again, the core piece here is, does it impact that market value, right? Does it respect the market and avoid, and this is that next piece, does it respect the market and avoid allowing somebody to substitute whatever you're doing here for the real thing, right? If it competes in the same market or you're using it for commercial use, odds are it's going to be problematic for you if you're trying to weasel this in under if you're making money, you're probably going to need to get a license. That's about Factual versus creative. Factual sources, you know, are going to tilt a little safer than creative. You know, it's very, it's very interesting how that plays, but that's kind of how it is. And then content and context and controls. So who has access to the thing that you're putting out, right? If you've got this limited access, limited impact, it's not going out, is it attributed properly? There's no redistribution, um, and there's no public facing commentary that, then at that point, your risk that you're impacting that market again is pretty low. And so you've got a reasonable control set there. And so there's certainly an opportunity to take advantage of fair use. But again, and I want to emphasize this, fair use is a defense. It is not, there's no smoking gun on exactly where the line is. And so the important piece here is, hey, get a license, especially if you're making money on it. And if you're not, then consider your options carefully. Um, safer alternatives, let's talk about those for a second. If you're making money, get a license. Music and promotions, cover images, any posts, full frame photos, artwork, merchandise of your merchandise or your competitors' merchandise, anything that competes with the original licensing market is going to cause a problem for you. Alternatives are, you can always take a picture yourself, right? If you can get an image of the thing yourself, get the image. If you can find something that is public domain, a good example would be US government works. Those are all generally public domain. Creative Commons works. Some may or may not require attribution. Some licensing, Creative Commons licensing allows for redistribution. But again, you have to be very careful about where you're getting these from and make sure that it's the original artist who's got this Creative Commons license. Because if it's not the original artist and somebody's just grabbed something off the internet and said, oh yeah, it's Creative Commons, you don't get much of a shield there. So it's always something that could become a problem. Get a license from a license library, Getty Images, Adobe, Shutterstock. One of these image libraries, commercial image libraries, are great sources for these images or these videos or audio clips that you might need. And then a lot of times, check your other licensing avenues. Oftentimes, your TikToks and Instagrams of the world will have business licensed audio or potentially video, or even sometimes, depending on the platform, images and many other options where they're licensed, they're fully licensed. And then the last thing is, you can always ask if you can get it in writing that, yeah, the original creator has authorized me to do whatever with this, certainly, it is something that would basically shield you. And I think the most famous example that I can think of that, having once been a young elementary school boy, is Spaceballs. I think if memory serves, I was reading an article at one point or another that talked about how Mel Brooks had gone out and gotten permission from George Lucas, when Lucas owned the thing, to basically make a parody. And there was a whole conversation about that. So certainly something to think about, as we go forward. So, if you've got questions about fair use, again, always talk to your attorney or, somebody who is very familiar with fair use. Be aware that fair use can exist, but understand that oftentimes it may be a limited resource. And so it's certainly something that you'll need to be thinking very carefully about. My name is James Greenwood. I'm an attorney licensed in Illinois. as a reminder, this should not be used as legal advice, and merely watching this doesn't constitute legal advice. You should talk to your own attorney and get advice about your specific situation. Thank you so much again for joining us in our latest IP at Lunch micro webinar series. And I look forward to seeing you at the next one. Have a great day. Goodbye.